is authorized, the preliminary investigation starts. So after a period of time, investigation, interviews, subpoenas, or whatever is done to confirm that there is a preliminary case here, it is taken back to the investigating director. The matter is considered by management, and then a full-blown investigation, Section 28.1, is approved. So within the Section 28.1 investigation, if there's additional expertise, additional investigators, or other role players that need to form part of this investigation that has come up now from the preliminary investigation, these additional people are added on to the designation and authorization of this full-blown investigation. Thereafter, the team is assembled, the prosecutors, the investigators, and the investigation commences, directed and led by the prosecutors. The investigators in that team, or I should say, to list that team, is a Deputy Director of Public Prosecutions. There are senior advocates, junior advocates, depending on availability, one or more. And then there's a Chief Criminal Investigator who is responsible for the senior criminal investigators and the criminal investigators. They report directly to the Chief Criminal Investigator in that structure. So once that is put together, the Chief Criminal Investigator assembles his investigators. He's got more or less the puzzle on hand of the investigation, and then he tasks the investigators accordingly. So in that specific task, it will be like, for example, myself, that is appointed now to conduct this investigation with the assistance of the other investigators. So you go out, you interview, obtain witness statements, other related evidence, and that is brought back. The team, together with the prosecutors, look at this evidence, they analyze this evidence, the prosecutors look at it, and if they see that there is sufficient evidence based on facts, then they will start with a charge sheet on who they're going to charge and what charges they're going to put. So a memo is put together with a charge sheet. That charge sheet and the memo is presented to the Deputy Director of that team. He looks at it to see that, okay, the facts, the evidence is supported by facts, that there is evidence, and the docket is now ready. That is then now taken to management. It's presented before management. Management will decide, yes, they agree that it should go on, and then the next step is the matter is ready to be enrolled. So the enrollment procedure is thus: you look at the prosecutors look at the charge sheets, they get the charge sheets ready. They also do a consultation note, which is a note to the Director of Public Prosecutions in the region where the matter is going to be prosecuted. So that consultation note is sent to the Director of Public Prosecutions. He or she agrees that yes, you can proceed to prosecute the matter in that particular region. Once that is done, the charge sheet is prepared. Then the enrollment processes start, where an application is made for J50s, that is your arrest warrants, or your J175s, if that is necessary, depending on the circumstances. Then
you say J175?
It's a summons. It's a summons to appear. So once that is done, your warrants are prepared, your affidavit is prepared, your warrants are prepared, and then you are ready for court. So then you will plan your operation and to execute your summons or your J50s. You will also have, depending, during that time you will pick up, but this is a Schedule 5, Schedule 6. Then you'll start preparing bail affidavits, because With regards to Schedule 5, there are serious offences, and it will be on the onus on the accused for him to be released on bail. So then you make arrangements with the court, you have the matter enrolled, and then the processes flow from there.
Thank you.
So are you at the level of process at this stage?
Yes. Clarification
just on process. All right. But maybe let me ask this. What's your understanding of the triggers or the entry points in accordance with paragraph A of the subsection, that is 7(1)A, capital A, the smaller a being paragraph A of the section. What's your understanding of the triggers or the entry points? I know this is a legal question, and we as commissioners must engage in an interpretative exercise. But what I want to get an idea of from you, because you apply the section in your daily activities, but as I say, we will have to interpret it for ourselves. It refers to investigations relating to, I would say, 3 triggers: serious, high profile, or complex, and then the complex corruption, and that seems to relate, the third relates to commercial or financial crimes. But the question I want to raise is, must this be read conjunctively, in the sense that all 3 triggers must be present, or must it be read disjunctively, in the sense that one trigger may be sufficient? You don't have to have a serious, high profile or complex corruption case. If it's serious, that may be sufficient, but it's doubtful that high profile all on its own would be enough, because something that's not serious at all may be high profile in the sense that it's out there in the public domain, and the public in general is interested in it, and it's high profile in that sense. So high profile may be doubtful standing all on its own, but I just want to get an idea of how you apply this in practice. Is it disjunctive? Is it conjunctive?
So my understanding of it is that it's just serious and complex corruption. That's how I look at it and how I read it from my perspective.
So all 3 triggers, as I call them, must be present. Is that what you mean?
When you look at the serious, high profile or complex corruption, any one of the 3. It's any one of the
So it's disjunctive.
Yes.
Thank you.
If I may follow up.